Welcome to Diagnosing Health Care, a podcast featuring thought-provoking conversations about the latest legal, policy, and regulatory issues in healthcare and life sciences. While these issues may seem like hurdles, we'll also look at the business opportunities and solutions that exist. Diagnosing Healthcare is brought to you by the lawyers at Epstein Becker Green, a leading law firm that has decades of experience serving clients in the healthcare and life sciences industries nationwide.
Today on Diagnosing Healthcare, we will discuss the ongoing legal battle over Mifepristone, a prescription drug used for the medical termination of early pregnancy, and examine implications for industry stakeholders, including drug manufacturers, distributors, providers, and patients. Hello and welcome. I'm your host, Avery Schumacher. I am an attorney in Epstein Becker Green's healthcare and life sciences practice based out of our Columbus office. During the past several turbulent weeks for the U.S. healthcare system, rulings in the case Alliance for Hippocratic Medicine versus the FDA have called into question the U.S. Food and Drug Administration's scientific review process to approve new drug applications. While the U.S. Supreme Court acted on the afternoon of Friday, April 21st, 2023, to preserve access to the drug Mifepristone while the case continues in the United States Court of Appeals for the Fifth Circuit, the future of Mifepristone and the FDA's authority to approve new drugs will continue to be debated on appeal. EBG is following developments closely and regularly advises clients on the practical and operational implications of the continuing controversy. On today's show, we're going to talk about the ongoing legal battle over Mifepristone, including a review of what has happened in the case to date and discussion of what is at stake depending on the ultimate disposition of the case. If you like what you hear today, please subscribe to the show. Diagnosing Healthcare is available wherever you get your podcasts. Joining our discussion today is Erin Sutton. Erin is an associate in EBG's Chicago office, where she focuses her practice on helping clients navigate complex regulatory issues. Prior to joining the firm, Erin was in-house counsel at a physician lobbying organization, directly advising physician members on litigation affecting regulatory and public health issues. Also joining us today is Delia Deschaine. Delia is a partner in EBG's Washington, D.C. office who focuses her practice on counseling pharmaceutical and biotechnology clients on a broad range of FDA and controlled substance regulatory matters. Welcome to the podcast, Erin and Delia, and thank you very much for joining me.
Thank you. It's great to be here.
Thanks, Avery.
Okay, we will jump right in. Before we get into the current controversy, I think it would be helpful to discuss some background information about Mifepristone and how it is used and prescribed. Erin, we'll start with you. Can you give the listeners some background about Mifepristone and include any specific information that may be helpful for them to understand the issues at play in the case?
Of course. Mifepristone is the first drug in a two-drug protocol used to terminate early pregnancy. The FDA originally approved Mifepristone back in 2000. It was approved under an accelerated drug approval process, a program that was created in response to the AIDS epidemic, trying to get medications out to the public with a quicker FDA review. The cost of that, or the side effect of that, was to have a risk evaluation and mitigation strategy for any drug that the FDA thought might have a benefit of having some safety requirements. So Mifepristone had a REMS that included things like restricting its dispensation in the presence of a physician, requiring multiple office visits, requiring a patient agreement form, etc. Since it was originally approved in 2000, the FDA has continued to revise that REMS, including most recently in 2023, when it removed the in-person dispensing requirement to allow or continue to allow Mifepristone to be prescribed via telehealth, a practice that was allowed based on the FDA deciding not to use its enforcement power to enforce the REMS during the public health emergency in the pandemic. So to date, right now, even though we've had all this litigation happening and sort of confusing the status, Mifepristone remains accessible. It remains governed by the 2023 REMS. And a few just points of information that I think will help our discussion is to understand that there is a brand name of Mifepristone called Mifeprex that is manufactured by the company Danco. Danco is an additional defendant in the litigation that we're talking about. Also, it's important to know that mifepristone is approved in a generic form.
Great. Thanks, Erin. Very helpful. Delia, is there anything that you want to add on the general topic of mifepristone background before we dive into the case?
No, I think that's a fair summary. I think there's been quite a bit of activity related to mifepristone's approval since it was first approved in 2000. Its approval in some ways has been somewhat controversial for some of the reasons that are stated in this case, and simply because it is a drug that is indicated to assist in medication-induced abortion. And so this drug, in some ways, in this case, is sui generis, but at the same time, many of the issues that are implicated are going to be broadly impactful to the entire pharmaceutical and biotechnology industry, which is why we've seen the case garner so much attention, both in the press as well as by amici in the case.
Great. Thank you both. So it sounds like mifepristone has been around for 23 years, so it's not a new drug, but its approval process and the REMS that goes along with it there's been some controversy involved, and that has brought us to where we're at in this case, which can have broader implications beyond mifepristone access. So next, let's examine the case facts and judicial history, basically answering the question, what happened here? This context is necessary to understanding the implications of the recent Supreme Court order to stay and what the ultimate decision in this case will mean for mifepristone and FDA authority more generally. Delia, we'll start with you first on this one. Can you describe what this case is about? Who are the parties and what are their positions?
Sure. So this case involves a challenge to FDA's approval and subsequent actions regarding mifepristone, which Erin helpfully summarized a few minutes ago. The lead plaintiff in the case is the Alliance for Hippocratic Medicine, which described itself in the complaint as a nonprofit organization that upholds and promotes the fundamental principles of Hippocratic medicine, including protecting the vulnerable at the beginning and end of life. AHM was incorporated in August 2022 and is headquartered in Amarillo, Texas. Other plaintiffs in the case include 3 out-of-state anti-abortion groups, the American Association of Pro-Life Obstetricians and Gynecologists, the American College of Pediatricians and Christian Medical and Dental Associations, in addition to 4 doctors. The plaintiffs are represented by the legal advocacy group, the Alliance for Defending Freedom. The defendants are the FDA, various senior officials within FDA, and the HHS secretary. The manufacturer of brand mifepristone, Danco, has also intervened as a defendant in the case. The plaintiffs allege in their complaint that FDA wrongfully approved mifepristone for use in medication-induced abortion in 2000 because FDA lacked authority to do so under its regulatory authorities. In particular, the plaintiffs allege that FDA wrongfully relied on regulations that were promulgated under Subpart H to approve the drug. At the time, Subpart H was the sole regulatory authority that allowed FDA to impose certain post-approval requirements on a drug, such as a restricted distribution scheme, which is in part why, or maybe entirely the reason that FDA relied on that section of the Code of Federal Regulations to approve mifepristone. The plaintiffs allege, as they did in their 2002 citizen petition to FDA, that Subpart H only applies to treatments for serious or life-threatening diseases, and that pregnancy is not a disease. Therefore, FDA did not have statutory authority or regulatory authority to approve mifepristone under Subpart H. The defendants, on the other hand, contend that Subpart H also applies to conditions and that pregnancy is a serious and life-threatening condition, or at least it can be. The defendants contend that FDA approved mifepristone under its statutory authority to approve new drugs, which is set out in 21 U.S.C. Section 355, and that FDA had ample authority to do so based on multiple adequate and well-controlled clinical trials that demonstrated the drug has adequate safety and efficacy to be marketed in the US for its approved indication. The plaintiffs challenge other FDA actions with respect to mifepristone, including its decision in 2016 to approve a labeled indication change and modify the mifepristone REMS both in 2016 and in 2021. The plaintiffs' arguments implicate FDA's approval authority and historic application of that authority broadly. And therefore, as I mentioned before, this case has garnered the attention of the pharmaceutical and biotech industry well beyond just mifepristone's manufacturers. Several industry members, as well as their trade associations, have filed amicus briefs in the case. And some of the plaintiffs' arguments that have generated attention by industry broadly include the argument that FDA, one, should have limited mifepristone's approval to the same conditions of use that existed in the clinical trials that supported the drug's approval. That's not something that FDA has historically required, nor is it a tenet of the FDA approval process. And defendants argue that that would be a significant upending of the FDA approval process and potentially require FDA to impose conditions of use on a drug when those conditions are not scientifically justified. So that argument has, in many ways, generated a very strong response from industry. Another component of the plaintiff's claims that has been recognized as potentially problematic for industry as a whole is the claim or assertion that the plaintiffs have standing to challenge FDA's approval of the drug and that their complaint is timely, despite the fact that the statute of limitations has run since mifepristone was originally approved and FDA denied the plaintiff's citizen petition challenging that approval. So it's a very interesting case for many reasons, in particular because of its potentially broad application to the pharmaceutical industry as a whole.
Thank you, Delia. A lot to unpack there, but you did a great job of clearly enlightening us. Follow-up question from that. You mentioned the standing argument. Erin, are you able to unpack that a little bit more, what the standing implications are that are being raised in this case?
Sure, I'll take a stab. So usually the Supreme Court has been perceived as being particularly vigilant on the issue of standing. And just to back up, standing is the ability to bring a case to any court or to an Article III court that you have suffered an imminent injury or will suffer an imminent injury, that the court is able to address your injury and give you a remedy through that particular case. So there are some issues here of whether or not the court is really the right venue for this dispute. And I think, it's usually a good indication that there may be standing issues when you have amici line up like we've seen in this case where, sort of half of the U.S. states are filing an amicus brief on sort of one side of the case and maybe half of the states are filing amicus briefs on the other side of the case. That usually might indicate that we're dealing with a very controversial issue that might have broad-ranging impact outside of that case. Here, the plaintiffs allege that they have been harmed by the availability of mifepristone because they may have, or their colleagues may have had to treat patients who've come into the emergency room with complications due to mifepristone. But in particular, they state that the real harm is that moving forward or looking forward, they anticipate that because the FDA has dropped the in-person prescribing requirement, for example, that they anticipate a greater wave of patients to come in and for those patients to experience complications due to allegedly taking mifepristone, and that those physicians will have to treat those patients. This is quite unusual because, as it's sort of acknowledged in the briefing, this sort of is the physician's duty. This is the physician's job, is to treat the patients that come before them. Typically, the safety profile of this drug is quite safe, and there really have not been the sort of incidents that the plaintiffs allege. So there are a lot of questions here as to whether the plaintiffs are going to really suffer harm in the future should the drug that has been approved for the past 23 years remain on the market, and also whether the court is really the right venue to give them the relief that they seek. Does the court really have the ability to address this issue by rolling back or perhaps invalidating the regulatory safeguards that are in place right now?
Very helpful. Thank you, Erin. Now that we understand what the issues in the case are, I'd like to hear, what did the district court hold? And I think we've touched on this already a little bit, what the practical implications are of the district court's holding, to the extent that we haven't already covered those implications in just describing the issues at play in the case.
Great. Thank you so much, Avery. Yeah. So what happened at the district court level is that the district court granted plaintiffs' request for a preliminary injunction in part and issued a stay on FDA's original approval of Mifepristone, which, as we talked about, happened in 2000. That's, of course, stayed FDA's subsequent actions with respect to Mifepristone, including the REMS and the labeled indication changes that we talked about earlier. The court held that the plaintiffs had standing to assert their claims and that such claims were timely. In particular, the court held that the statute of limitations did not bar plaintiffs' challenge to Mifepristone's approval because FDA had reopened its initial approval decision when it later approved changes to the drug's labeling and REMS in 2016 and 2021. The court also held that the plaintiffs were likely to succeed on the merits of their claim that FDA acted unlawfully in approving Mifepristone in 2000 and its subsequent modifications of the labeling of Mifepristone. So in terms of practical implications of the court's ruling, while the court temporarily stayed its stay to allow for the defendants to file an appeal with the U.S. Court of Appeals for the Fifth Circuit, which the defendants did, what promptly erupted in industry was essentially regulatory chaos, right? Healthcare providers, dispensers, distributors, state public health authorities, and other members of the supply chain, and frankly, stakeholders had to work very quickly and were working very quickly to ensure that they had procedures in place to comply with the court's order if and when it became effective. Several entities did have anticipatory procedures in place. That didn't change the sort of uncertainty that existed within the healthcare industry as a whole as to what compliance really meant and at the time. And that part, in part, that uncertainty was driven by the fact that there was another federal district court ruling that was issued by a district court judge in Washington just minutes after the federal district court ruled in the Texas Mifepristone case. And that Washington district court order was in many ways opposite to the Texas district court's order. In a case that was brought by several states plus the District of Columbia against FDA, requesting that the court enjoin FDA's ability to change the status of Mifepristone's availability, the court ruled in favor of the plaintiffs in that case and ordered and preliminarily enjoined FDA from changing the status quo of Mifepristone's availability and approval in the US. And so naturally that created some question as to what the status of Mifepristone's approval was in any given state or across the US broadly, and how healthcare providers and other stakeholders and industry members should comply. It also created some question naturally within the government as well, which is why the Department of Justice, on behalf of FDA, filed a request for clarification with the Washington District Court, asking the court to clarify the scope of its order. As you can imagine, the state of play in industry and beyond after the district's court order was pretty erratic.
Thanks, Delia. So as if the holdings from the district court that we've been discussing weren't confusing enough, it sounds like the Washington District Court ruling just added an additional level of confusion into the mix. So now understanding what the district court in the Mifepristone case held, can you now explain to us, Erin, what the Fifth Circuit's response was to the district court's rulings and how that came about?
The Fifth Circuit, on top of everything, at midnight on April 12th, 2023, filed its opinion, and the effect of it was to stay the district court order in part and then allow in part the remainder of the order to go into effect. It happened a couple of days before the district court order was set to expire, leaving just a razor-thin window for the parties to appeal to the Supreme Court to get some additional clarification. The Fifth Circuit essentially said that the 2000 approval, the plaintiff's challenge to the 2000 approval of FDA was likely time-barred, and therefore that portion of the district court's order could not go into effect. However, everything that occurred after 2016 could be enjoined, could be stayed. And so that meant not only some of the REMS that we had talked about before, the updates to the REMS were no longer going to be in effect, but also something that happened in 2019 was the generic approval of Mifepristone. That was no longer going to be in effect. So you can imagine industry is scrambling to figure out, well, do I need two different systems, one for Mifeprex, one for a generic Mifepristone? What am I supposed to do with the Mifepristone that we have on hand? Is that something that we can keep? Is that something we need to dispose of? How are we going to do this? So you just can imagine that while the Fifth Circuit may have intended its stay decision to be sort of splitting the difference or taking the middle road, it actually caused just quite a bit of confusion in addition to the confusion surrounding the district court order.
Thank you, Erin. So it sounds like the Fifth Circuit's opinion had an effect of allowing access to Mifepristone to continue, but only to the extent that the dispensing of the drug complied with the REMS that was in place before 2016, so that access was not completely removed after the Fifth Circuit's response.
That's right.
Yeah. But I will just I do just want to add to that the fact that I think as the defendants appropriately pointed out in their briefs to the Supreme Court, that it actually isn't that easy of a shift to revert a REMS for a drug and the labeled indication for a drug that's currently in commercial distribution back to something that existed 6 or 7 years ago, right? There's actually a regulatory process that the manufacturer has to follow to update that labeling, to change how the drug's being manufactured and distributed, and actually has to get approval from FDA in order to make that labeled indication change. Despite how it may seem like the Court of Appeals decision was continuing to allow Mifepristone to be in the marketplace, practically speaking, it really did not have that effect and would not have had that effect if it had been stayed. There would have been some, at least temporary, disruption in the commercial supply of the drug, not to mention the fact that the Court of Appeals decision had the effect of enjoining the approval of generic Mifepristone. So the only version of Mifepristone that would be available in the marketplace was the brand drug, which anyone who understands the pharmaceutical landscape after a generic drug is approved appreciates the fact that that can radically change the amount of drug that's available in the marketplace and the affordability, frankly, of that medication. Although it may have seemed like a win, a partial win, it practically speaking was very problematic, which is why it's not surprising that the defendants promptly filed an appeal with the Supreme Court and that the Supreme Court granted the defendants a stay.
Perfect. Thank you, Delia. So though it may have sounded simple to revert to the pre-2016 REMS, it was anything but and kind of prompted a whole host of other issues that could cause the industry to spiral, leading us to the recent Supreme Court order to stay, which we will explore next. And what does that mean for stakeholders? I understand that this grant of stay provides some temporary relief from the confusion, but there's still a lot up in the air. Erin, can you tell us about the Supreme Court order to stay and what it means short term and whether there are any longer term implications?
Sure. So, as if it weren't dramatic enough, the stay was set to expire, and the Supreme Court actually asked for an additional 2 days. There's a lot of questions as to why that extra time was requested. But on Friday night, April 21st, the court did grant a stay. It did so on what's been referred to as its shadow docket, which means it's not a case that was granted certiorari that the court would review on the merits, but rather something that the court would address on a procedural issue like a stay. The court, therefore, didn't offer an opinion behind its decision. We're left to sort of wonder what maybe motivated the court or what might have happened behind doors to influence the stay. And I think we've done a good job of describing just sort of how chaotic it was in the interim between the district court order and then eventually making it up to the Supreme Court. Perhaps the court saw that and wanted to preserve the status quo prior to this litigation. But this is really speculation at this point. However, 2 justices did dissent. Thomas dissented without providing an opinion, and Justice Alito, who authored the majority opinion in the Dobbs decision, dissented, saying that he would not have granted the stay and actually calling into question the arguments that the prior to 2016 REMS would be difficult to reinstate, saying that the FDA could just exercise its enforcement authority and decline to pursue violations or pursue sanctions against holders of misbranded or what might be called misbranded drugs that did not have the correct information from prior to 2016. But that is just one justice's opinion out of 9. So we really are sort of left in the dark to wonder. However, an important factor to keep in mind is that a part of the analysis of whether or not to grant the stay is whether the defendants met their burden to say that they would have faced imminent harm, that they showed that they were likely to be successful on the merits of the case. So this could be influential to the Fifth Circuit, to the lower courts, while this case continues, that the Supreme Court, at least by vote, has indicated that the defendants met their burden, that they have shown that they are likely to be successful on the merits of the case.
I agree with that. But I also think at this point, there's so many other potentially competing factors that could have weighed into the court's decision that it's difficult to know why the court issued the stay that it did, right? So it's possible that the Supreme Court maybe agreed that the plaintiffs would be likely to succeed on the merits of their claims regarding FDA's approval, but that they lacked standing or that their claims were not timely. So at this point, I think there's still an open question as to how the court substantively will rule on these issues if and when it's presented with this case again.
Thank you both. So there's obviously a lot for industry stakeholders, including manufacturers, distributors, providers, and patients to be thinking about and keeping track of here. In addition to the obvious effect that the decision may have on access to medication-assisted abortion, what comes next may have sweeping implications for the FDA's authority. Delia, can you describe for us what comes next procedurally in this case? What are the possible scenarios that can play out judicially, and what should industry stakeholders be thinking about?
Sure. So the case is currently scheduled for oral argument before the Court of Appeals for the Fifth Circuit on May 17th. After that argument is held, the court will rule on the defendant's appeal of the district court's order. The decision likely then will be appealed to the U.S. Supreme Court, which may or may not grant certiorari. If the court does grant cert, then the status quo of Mifepristone's approval will continue until the Supreme Court issues a final ruling in the case. The potential outcome of this case and the potential scenarios that can unfold are, in many ways, almost seem limitless at this point. One potential would be for the case to go back to the district court for a full merits hearing, in which case the district court will rule on the substantive issues that the plaintiffs have raised. Certainly, what's at stake here, I think, for industry and what industry recognizes as being at stake is not only the availability of a drug that's been on the marketplace for over 23 years and is a key component of the medication-induced abortion protocol in the U.S., but the reliability, and the integrity of the drug approval process as FDA has applied that process and as industry has come to know that process to date. So as we talked about a little bit earlier, the district court's original decision that the plaintiffs had standing in this case and that the statute of limitations did not bar their challenge to Mifepristone's approval because FDA had reopened its decision to approve Mifepristone when it revisited the labeled indication for the drug and the REMS for the drug could create a forum in which virtually any plaintiff at any point in time could sue FDA and win to overturn a drug's approval. And that creates some significant amount of instability within the marketplace for medications in the US, not only for the sponsors and the manufacturers who rely on the stability of that process in developing medicines and their businesses to market those medicines in the US, but also the range of healthcare entities, including providers, hospitals, distributors, pharmacies, and other entities that prescribe, dispense, and distribute these medications. So how the courts ultimately decide that issue will be very impactful to industry. There's also some potential for this case to implicate how FDA decides whether a drug is adequately safe and effective for marketing in the US. As we talked about earlier, the plaintiffs really do challenge FDA's decision to not impose the same conditions of use on Mifepristone's approval that existed in the clinical trials that supported that approval. And that's not something that FDA has historically done, nor would industry sort of recognize as being, or FDA recognizes as being scientifically justified. The clinical trial process is really a very controlled environment. It's intended to elucidate evidence that will demonstrate whether a drug is going to be adequately safe and effective in the clinical setting, which inherently will not have the same controls as the clinical trial environment. So this notion that the same conditions must exist in the real world that exist in the controlled clinical environment is novel and potentially very problematic for companies that are developing new drugs or have approved new drugs based on clinical trials that were not replicated in the labeled conditions of use for the drug. So needless to say, this is a case that has, I think, appropriately drawn the focus of industry, and it will be very impactful to industry once a final decision is made.
Thanks, Delia. Erin, anything that you want to add on that topic?
Yes, I just want to emphasize that this case is still very much alive. It's proceeding through the Fifth Circuit. Oral arguments on the appeal of the district court's order are scheduled for May 17th. So we will continue to watch and see what happens. While the Supreme Court's stay order, as cryptic as it was, could be influential, we just don't know. The Fifth Circuit will have more information to be able to make their determination. And it's quite likely that that will be appealed once again to the Supreme Court.
Thank you, Erin. It sounds like we will have lots to talk about in podcasts in the future. Lots
Yes.
to unpack here. So I want to wrap up by just asking each of you a question to perhaps answer in one or two sentences to leave our listeners with. Erin, your practice involves advising clients in this time of uncertainty. Is there one thing about this case that you can put a finger on that's keeping you up at night? Or alternatively, is there anything that gives you solace?
I think it's the same answer that we've been highlighting is the uncertainty is really what keeps me and our clients up at night in terms of this is a field in the past nearly a year that has just been so volatile with state court cases, federal court cases, state legislation, really changing the status quo of access to abortion, access to medication on a sometimes near day-to-day basis, if not week to week and month to month. In terms of this case, I think it's sort of emblematic of some of the uncertainty that we've been feeling for the past year. I think it's a question that I will keep my eye on is how will the courts in general interpret the 1873 Comstock Act that prohibits items that can be used or adapted for use for abortion from being shipped through the mails. This is a law that has been completely untested in the post-Dobbs, post-Roe era. So since Dobbs, we just have no idea how courts are going to interpret this. While we've seen the Department of Justice have one opinion on how this law should be enforced, such that only things that are intended to cause unlawful abortion are prohibited, we've seen states push back and say, no, anything that could be used for an abortion is not allowed to be mailed. That is an element of uncertainty that has been raised in this case. So far, the parties have briefed it, but the courts really haven't spent a lot of time analyzing this. So it could be an opportunity in this case to get some clarity, some clarification on what's going on. But yet again, it is something that causes me concern because it could be broader than just medication. It could be anything, it could be devices. It could be sort of any sort of medical equipment, anything that could be used or intended to assist in causing an abortion. The thing, though, that does give me solace is trying to stay ahead of these changes, trying to stay abreast of these changes by tracking them, remaining vigilant. And I think our biggest tool has been really staying on top of all of these decisions to the extent that we can on a statewide, national, legislative, litigation level so that we can really give people timely advice as to what is the status quo right now in XYZ state or across the country. So we'll continue to do the same regardless of the outcome of this case.
Thank you, Erin. Delia, I just wanted to turn to you and ask the same question. Your practice also regularly involves advising clients in this time of uncertainty. Is there one thing in this case that keeps you up at night? Alternatively, anything that you'd want to mention that gives you some solace?
No. I mean, I don't think there's any one thing that keeps me up at night. I think there are several things that sort of keep me up at night, and some of which we've talked about earlier. But at the same time, perhaps one thing that gives me solace is the fact that there's so much interest and it seems like intervention in this case. So I do think that the perspectives, at least of the pharmaceutical and biotechnology industry, are being represented in a way that will allow the courts to meaningfully weigh these issues. Well, probably wouldn't hurt for us to have sort of more of a provider perspective on these issues. Certainly, given that's the plaintiffs who have filed this case, but I do take comfort in the fact that this case is getting, I think, the attention that it deserves by industry.
Thank you, Erin and Delia, for taking the time to participate in today's discussion and for sharing your experience and thought leadership on this podcast and elsewhere. And also, thank you to all of our listeners. I'm your host, Avery Schumacher. If you like what you've heard today, please don't forget to subscribe. Diagnosing Health Care is available wherever you get your podcasts.
Thank you for listening to Diagnosing Health Care. For show notes on today's episode, additional episodes, and more insights on trending issues in healthcare and life sciences, please visit diagnosinghealthcare.com and be sure to subscribe on your preferred platform. This podcast is presented by Epstein Becker Green, PC. All rights are reserved. This audio recording includes information about legal issues and legal developments. Such materials are for informational purposes only and may not reflect the most current legal developments. These informational materials are not intended and should not be taken as legal advice on any particular set of facts or circumstances, and these materials are not a substitute for the advice of competent counsel. The content reflects the personal views and opinions of the participants. No attorney-client relationship has been created by this audio recording. This audio recording may be considered attorney advertising in some jurisdictions under the applicable law and ethical rules. The determination of the need for legal services and the choice of a lawyer are extremely important decisions and should not be based solely upon advertisements or self-proclaimed expertise. No representation is made that the quality of legal services to be performed is greater than the quality of legal services performed by other lawyers.